Canada has had public sector privacy laws for more than 30 years and private sector privacy laws for 25 years. You would think it would be straightforward to figure out what privacy law applies to any particular activity. It's 2025 and this should be settled, but it's not. And I think that's because of the way the privacy commissioners have been misapplying Canadian privacy laws. I'll explain how. Hi, my name is David Fraser. I'm a privacy, internet, and technology lawyer with the Canadian law firm McGuinness Cooper. I also teach internet and media law at the Schulich School of Law at Dalhousie University. We have 3 different kinds of privacy laws in Canada, and each of them use a different basis for the handling of personal information. We have public sector privacy laws, which regulate government, federal and provincial, crown corporations, and entities like municipalities, schools, and public universities. They don't handle personal information based on consent, but instead based on lawful authority. You don't get consent or withdraw consent for a school board to have your kids' personal information. I note that police are subject to public sector privacy laws and the Charter, and these privacy laws have massive loopholes for law enforcement purposes, collection, and use of personal information. That's just a fact. Then we have health privacy laws that regulate the public and private delivery of healthcare in Canada. They're based on what I consider a legal fiction, knowledgeable implied consent. Essentially, consent is assumed for all necessary use of your personal information to provide you with healthcare, also assuming that you're generally made aware of how that information is collected, used, and disclosed. Finally, we have private sector privacy laws, which regulate businesses. How far this goes depends on the jurisdiction. In some provinces, that includes not-for-profits, but in the federal jurisdiction, it only applies to the collection, use, and disclosure of personal information in the course of commercial activities. Private sector privacy laws are exclusively based on knowledgeable, informed consent. To borrow a European legal term, the legal basis for processing personal information varies widely whether you're in the public sector, health sector, or the private sector. Who is the regulator also varies. So you really want to know what law applies to what you're doing. Now, daily, companies and public institutions contract with third parties to provide services on their behalf. The contracting company will almost always know what law applies to them and to that activity. For example, if a government institution subject to the Privacy Act does an activity themselves, it is only subject to the Privacy Act. If they retain a private company to do that activity for them, that activity, in my view, should only be subject to that Privacy Act. If the government institution can lawfully do it under the framework that they're governed by without further consent, that should be the same for the private service provider who does it for them. But if you get a regulator who says that the service provider has to also comply with PIPA, in some cases, it simply can't be lawfully performed. As I said, the Privacy Act is not based on consent. It's based on lawful authority. Governments don't need your consent. You want a passport? The collection, use, and disclosure of your personal information associated with getting a passport is regulated by the law, not your consent. Similarly, you don't get to consent to having your personal information registered in the Registry of Deeds if you buy a house. That's just the way it is. Certain regulators' orders and findings and public statements bring into question what law will apply to the contractor, even if they are purely a processor. That affects both the contractor and the principal. And taken to its logical conclusion, it brings into question whether a Canadian company can provide services, for example, to a European company. A prime example is the joint British Columbia federal investigation into a company called Aggregate IQ. Aggregate IQ was a British Columbia company that was involved in the Cambridge Analytica scandal. It provided services as a contractor to election campaigns around the world. The commissioners both determined that because that company was in British Columbia/Canada, they must themselves also comply with the Personal Information Protection Act and the Personal Information Protection Electronic Documents Act, regardless of the location of the individual concerned, or even the laws that their customers were subject to. In providing services to a client in Europe, where there is a lawful basis under the GDPR to process personal data without consent, the commissioners in Canada said the contractor still had to get consent because that's a requirement under PIPA and PIPA, the BC and federal privacy laws respectively. A quote from the joint finding, quote, "Our investigation revealed that AIQ did not take any steps other than agreeing to a broad contractual clause requiring the parties to comply with data protection laws to ensure SCL had obtained consent from the individuals whose personal information AIQ collected from SCL, used or disclosed in its work for SCL. AIQ stated that it did not think it needed consent based on its understanding that privacy laws in the US did not require consent." They go on to say, on the above point, we highlight that AIQ remains responsible for complying with the consent requirements for its personal information handling practices in accordance with the applicable Canadian or BC privacy laws, even where its clients are located in another jurisdiction. They go on to say at paragraph 70 in the finding, in the circumstances, we would have expected AIQ to have ensured that there was adequate consent for its collection, use, or disclosure of personal information on behalf of SCL. The fact that it did not do so is particularly concerning since certain information used to target individuals would have been sensitive, e.g. ethnicity or psychographic profiles, which would generally require express consent. So in the next paragraph, they kind of allude to the problem that they're ultimately creating. So they say, to be clear, we're not finding in this section or below that AIQ's foreign clients were required to comply with Canadian and BC privacy laws. The practices of those political organizations would generally fall outside the scope of PIPA and PIPA, and in any event, were not the subject of this investigation. That said, to the extent that AIQ wished to rely on the consent obtained by those foreign clients for its own collection, use, and disclosure of personal information on their behalf, it would need to ensure that such consent was sufficient under Canadian or BC law, as the case may be, for its purposes. The commissioners also wrote, quote, as noted above, PIPA does not set out any specific exceptions to consent for an organization that collects, uses, or discloses personal information on behalf of another party for that party's purposes, for example, as a service provider or processor. Rather, PIPA applies to organizations that collect, use, or disclose personal information in the course of commercial activities more generally. Okay, this, in my respectful view, is bonkers, and it raises a bunch of issues, which I'll discuss in greater depth. Another example relates to the OPC's finding related to the proposed use by the Royal Canadian Mounted Police of Clearview AI facial recognition and the OPC's investigation of the RCMP's collection of open source information under something called Project Wide Awake. These essentially say that private sector service providers to the RCMP, which is subject to the Privacy Act, must also comply with PIPA, even where the collection, use, or disclosure is only carried out on behalf of the RCMP. All of these activities would be lawful for the RCMP to carry out on their own, well, thanks to the appalling lack of guardrails in the Privacy Act. But if you think that the RCMP should not be able to compile a massive facial recognition database on their own, then advocate for changes to the Privacy Act and its provincial equivalents. There really should be much stricter scrutiny and oversight of how police collect and use personal information, particularly using technologies. But this is not the way to do it. I'm told that this is actually having an effect on the ability of the RCMP to use third-party tools to investigate significant cybersecurity threats to Canada and Canadians. We need to, the privacy commissioners need to rethink this. Imagine this pretty realistic scenario for which I'll make up or guess a few facts. The province of Nova Scotia enters into a contract with an electronic health records company headquartered in Vancouver, British Columbia, to provide the electronic health records system for the entire province. It's pretty clear that the Personal Health Information Act of Nova Scotia applies to the province, hospitals, and the doctors. What law applies to the EHR vendor with respect to their activities? So the Aggregate IQ finding would suggest that BC's PIPA would apply. One might even say that PIPA applies as well, since the substantially similar exception order under the Nova Scotia Act only carves out the collection, use, and disclosure of personal health information that occurs in the province of Nova Scotia. Any personal information in that system that is not personal health information is also excluded from the exemption order. So the vendor would have to get opt-in consent given the sensitivity of the information, and they can't rely on the knowledgeable implied consent, i.e. legal fiction standard, from Nova Scotia's Personal Health Information Act. If you again follow the logic of the Aggregate IQ decision, that information is subject to 3 laws with 3 regulators and 3 different bases for processing. And that's just dumb. That's just unworkable. Here's another scenario. An Alberta-based company provides a software-as-a-service human resources information system to a provincially regulated company in Ontario to manage HR, scheduling, payroll, etc. What law applies to the company? There's no law that regulates the collection, use, and disclosure of employee personal information in Ontario. The employer can do whatever they want. But the Alberta company, following the above, would have to get adequate consent from all of the Ontario employees. It's lawful in Ontario, but these privacy commissioners' findings suggest it's unlawful for an Alberta company to carry out that otherwise lawful activity on behalf of the Ontario company. unless they got adequate consent, which is completely unworkable. So I'll throw another example into the mix. You get a company in New Brunswick is hired by the government of Quebec to print provincial driver's licenses. The Quebec government is clearly covered by the Quebec public sector privacy law. The company in New Brunswick is engaged in commercial activity. So the Federal Privacy Commissioner would say that what they're doing is regulated by PIPA. But it relates to information about residents of Quebec being processed by an enterprise. So the Quebec Commissioner may take the view that the New Brunswick company is subject to the Quebec private sector law. That's not just an annoyance, but that could expose the company to the massive fines added to the Quebec private sector privacy law. Would you want to take that contract? It's pretty clear that Aggregate IQ and Clearview AI are the bad guys in each of the cases, and the commissioners want to rein in what they're doing, but these findings create a precedent that is extremely problematic. It's also pretty clear to me that the federal and British Columbia commissioners just really wanted to give a good smackdown to Aggregate IQ because of their involvement in the Cambridge Analytica scandal. But the way they did it actually creates cascading problems throughout our privacy regulatory system that regulates bad guys and good guys, and this will have collateral effects. The reality is that this flies in the face of some pretty persuasive jurisprudence. About 15 years ago, I was counsel to the State Farm Automobile Insurance Company in a matter that found its way to the Federal Court of Canada. In that case, the Privacy Commissioner of Canada asserted that the collection, use, and disclosure of personal information in the course of defending a car accident lawsuit was subject to PIPA. Now, that is on its face a bonkers assertion. The plaintiff in that case attempted to revoke any consent to the collection of their personal information, which was collected in order to fairly and lawfully defend their insured in the lawsuit. They also tried to use the individual data subject access request rights to get their hands on records that the rules of court said they weren't entitled to, but PIPA contains no such exception. So essentially, I'm going to sue you, but you can only defend yourself with both hands tied behind your back. Now, see how dumb that sounds? The Privacy Commissioner then agreed with the individual that State Farm and its lawyers and private investigators were all subject to PIPA. So ultimately, we took the Privacy Commissioner to court, and the court rightfully said that you can't just wave your hands and say that if an organization is commercial, all of its activities are commercial regardless of the context, and thus engages PIPA. The court said this was ultimately about a dispute between a plaintiff and a defendant arising from a car accident. That's not commercial. The fact that the defendant had insurance, which they lawfully must have and that they paid for, and the insurer had lawyers who expected to get paid, didn't change the fact that it was about a non-commercial car accident. Imposing PIPA in there made no sense and would actually make the litigation unworkable. In the Aggregate IQ case, the Privacy Commissioners faulted the company for how it handled information of British voters in a British referendum that was done, as far as they knew, in compliance with British law. In that case, it certainly should be up to Britain to determine the standards for the collection, use, and disclosure of their citizens' data in connection with one of their elections. What does Canada or British Columbia have to do with that? So what's the solution? I think our laws should be amended to be clear that when an organization is acting purely as a service provider to another, the laws that apply to the other company should apply to that activity. I could write that amendment in one paragraph, but of course it would require amending more than a dozen Canadian privacy laws federally, provincially, and territorially. The easier route is just for Canadian privacy regulators to recalibrate their thinking to take this into account and realize the possible far-reaching effect of making findings on a desired outcome. If you have a private sector company providing services to another company, the focus should remain on the actual underlying activity and not who is doing it or where. If the Government of Canada made a particular framework to regulate how the RCMP collects, uses, or discloses personal information, it should not matter whether the RCMP does it themselves or has a contractor do it for them. It's worth noting that in 2023, the UK's first-tier tribunal overturned a UK Information Commissioner finding against Clearview AI, largely on the basis that Clearview AI was collecting data on behalf of clients outside of the UK, outside of EU, and who are not subject to the privacy law in effect at the relevant time. So don't hate the player, hate the game. If you've made it to the end, you're likely someone who should subscribe to this channel. I try to put out a new video every few weeks, so if you're interested in this sort of content, please click the like and subscribe buttons. There's a bell somewhere to get notified of new episodes. And also leave a comment if you have any questions or if you have any suggestions for other topics to cover. And of course, feel free to share this with anyone who you think may be interested in hearing about Canadian tech and privacy law. Thanks for tuning in.